Welcome to Q&A practice. We'll start out with a short warm-up, and we will start with the court. Ready? Here we go. Closing instructions. The parties can agree that's his phone number, right? Correct. If there were a written document and it's not objected to, then there is no pattern instruction 162 stipulation instruction to give, and most of these paragraphed stipulations are of the latter nature. In other words, we just agreed among us that I won't make an authenticity objection. You still have to prove up relevance, or I may or may not object under 904.03, but I don't have a problem with authenticity. Some of them go further than that. For instance, just as an example, we're stipulating that Lynn Hunter purchased a Motorola Razr V3 phone in August 2005, and we're going to allow admission of the contract and receipt without the calling of any witness. So I have no problem with simply accepting a written copy of the email, though I have already marked up the copy that was circled by, I believe, Mr. Katz or someone and given to me, so I will need a clean one, but I won't require the parties to put the agreement further on the record if they don't feel a need for it. Judge, what I will do, since what you have dated the 4th of February is actually a response to an email that I wrote to Mr. Strang on the 25th of January, I'm going to attach both of these as one exhibit. I will have it marked. I will have it received by the court, and this together is an accurate reflection then of what both parties agreed to. I don't have any problem with the procedure. And that's ideal because my February 4 email says, see your January 25th, 2007 email. I will also just make crystal clear that we're not walking away from the stipulation to the authenticity of the aerial photos. There is no objection to Exhibit 25. The issue is, and I fully accept Mr. Katz's explanations of what question he actually asked Mr. Drum. Once he repeats it, I think it rings a bell with me. All I can say is that sitting here as one attentive observer in my own mind when I heard Mr. Drum testifying, I was, I guess, assuming that Exhibit 4, inferring that Exhibit 25 was taken on November 4. And if I made that mistake, then jurors may have, so that's why we just need to clear up the date. It doesn't affect the admissibility or the authenticity of Exhibit 25. We have no quarrel with that. Well, again, I think perhaps the primary reason to clear up the date is not have the jury wondering whether or not the RAV4 is in that photo. The parties have already demonstrated to the jury that they have the capability to zoom in on these photos. So I think it will help the jury and everyone to know exactly when it was taken. Anything further this afternoon? It's a digital photo, Judge. I'm just telling the court because just something that I learned about the signature on a digital photo. It was taken, at least if the time in the camera is correct, on November 8th, 2005 at 7:15 a.m. using a Canon EOS Digital Rebel XT camera. I don't know what the court wants by way of information, but we'll try to verify that time and any other information. And I think it's a very valid point, and we'll alert the jury to that. I don't think the state needs to spend any more time verifying that. I mean, November 8, I don't have any reason to doubt, and the photo is perfectly plausible for having been taken on November 8. Okay, so I'm happy with that. Judge, if I may, page 185 of the Calumet County Sheriff's Department discovery on the third last paragraph actually talks about this very image, how it was taken and when and why and those kind of things. So page 185. All right, that notwithstanding, Judge, we will Oh, I'm sorry, Judge, I misspoke. I was hearing two things. Page 185, the third last paragraph is the information regarding the other cell phone that was found, that mystery one down by the river. The Mishicot cell phone, yeah, page 185 of the Calumet County Sheriff's Department report. Third from the bottom paragraph, that should be the information that Mr. Buting had been looking for. I'm sorry, but the other information as to the time and date of the aerial photo all seem accurate as well. That's all I have for today. All right. I will ask the attorneys to meet in chambers again at 8:30 just to give me the agenda for the day. See you tomorrow morning. All right. Thank you. So some more good colloquy practice. All right, now for some regular Q&A. And we will start with the plaintiff attorney. Ready? Here we go. Okay, and like I said, I had merged over into that first, the right turn, left turn lane, and I was riding alongside of him at that time. Okay, and my question to you is, okay, where alongside the tractor and the tanker trailer were you when he commenced to come into your lane as you suggest? Where, what part of the tractor and trailer were you in conjunction with when that occurred? I was more in conjunction with the trailer, more so than the tractor. Okay, now it's a long trailer, right? That is correct. Was your vehicle closer to the rear tandem wheels of the trailer, or was it closer to the middle of the trailer? Closer to the middle of the trailer. Closer to the middle of the trailer. Closer to the middle of the trailer. Okay, I've got your deposition transcript in front of you there, sir. If you could please draw your attention to page 67. Pardon me, if you go to page 66, line 22. Which is the last line on page 66. Let me know when you're there. What page, which line number? The very last line of page 66, line 22. You see that? Yes? Okay. I'm going to read with you, so I want you to make sure that I'm reading this accurately. Beginning page 66, line 22, I asked you a question now in terms of where you were in conjunction with the BTL trailer when you say it came into your lane. Were you about halfway down the trailer, or were you back where the rear tandems are? Your answer was back near the rear tandems, right? That's correct. Next question. So further towards the back of the trailer than the middle? Your answer, that's correct. That was your testimony at your deposition. That is correct. Okay, does that refresh your recollection that that's in fact, this deposition was taken back on the 7th of November 2007. I do remember that deposition. Okay. Do you agree that your deposition testimony is accurate? Yes. Okay. Did you ever progress further than the rear tandems of the trailer? Did you ever progress forward further than that point after he commenced to come into your lane? I can't recall. Okay, so the rear tandems back at the rear of the tanker, that's as far forward in terms of the tractor trailer that you got in conjunction with this entire event. Objection, overrule, correct. Okay, showing you what's been marked as Plaintiff's Exhibit number 2. Do you agree that in terms of Plaintiff's Exhibit number 2, your vehicle is the vehicle designated with the letter H for Honda? That is correct. And do you agree that in conjunction with this exhibit, you have placed your vehicle up near the rear wheels of the tractor? That is correct. Far further forward than the rear tandems, which are back here, right? Yes, that's different than your testimony today, correct? Correct. I believe today in court during your direct examination, you were asked by Plaintiff's counsel whether you checked in the left lane, checked your mirrors to see whether there was anything in the left turn lane before you made your lane change. And your testimony today, correct me if I'm wrong, was that you didn't look because you didn't have the time. Is that correct? That is correct. Okay, drawing your attention to page 34 of your deposition transcript. I apologize. Page 33, line 19. Let me know when you're there. I'm there. Line 19. I asked you before making the move, did you look in your mirror or side view mirror, your rear view mirror, to see if there was any traffic in that lane? Page 34. Answer, I had a split second to see that. Question, did you look? Answer, yes, I had a split second to see that. Question, and what did you see in that split second? Answer, I saw that I had just a split second to jump into the next lane. Question, did you see anything in that lane? Answer, no. Question, how long did you look? Answer, it was a split second. Do you agree your deposition testimony indicates that you did check to see if there was anything in the left lane, but you didn't see anything? That is correct. Your testimony today in court is, correct me if I'm wrong on that, following the collision between the Dodge and the rear of your vehicle, you immediately came to a stop, correct? After the accident, correct. There was a rear end collision, and then you came to a stop, essentially, right? It wasn't a sudden, I rolled a couple of feet and then stopped. And we will stop there, and that will conclude our Q&A practice.